Hello everyone, in this video we'll study about liabilities of auditor. Now, the functions performed by an auditor have grown immensely in importance, and this has resulted in establishing legal liability of the auditor not only towards the shareholders but also to the third parties. A plaintiff may bring action against an auditor under either common law or a statutory law. Now, under common law, the liabilities are held through court decisions, and statutory law refers to the laws that have been passed by the legislature. So, the liabilities of the auditor can be classified into two categories: liabilities under common law and liabilities under statutory laws. The liabilities under common law can be classified as civil liability for negligence towards client, and secondly, civil liability for negligence towards third parties. The liabilities under statutory laws can be classified as civil and criminal liabilities under the Companies Act 2013 and under the Income Tax Act 1961. Now, broadly, criminal liability occurs when a person commits an act that is considered to be wrong against the society. So, in this case, the offender can be fined, or he can be imprisoned, or there can be both of these cases. However, a civil liability involves a violation of the rights of some specific party, and in this case, the penalty is in the form of payment of damages. Next is civil liability under common law. Now, the client and the third parties can sue the auditor for negligent discharge of his duties under common law. The first subcategory in civil liability under common law is liability for negligence towards clients. Now, firstly, what do we mean by negligence? The term negligence describes the failure to exercise reasonable care and skill which is expected of the auditor while conducting an audit. Now, what constitutes reasonable care and skill? It depends upon circumstances of each case. But generally, an auditor will be made liable for his acts of omission, such as the failure of auditor to detect defalcations, or the auditor relies upon a certificate regarding valuation of stocks which was given to him by the management, even when there are sufficient grounds that arouses auditor's suspicion. So, even when there are sufficient grounds that an auditor can be suspicious about the valuation of stocks, still he relies upon the valuation of stocks given by the management. In that case, the auditor can be held liable for negligence towards his duties. Liability for damages for negligence. Now, even when the negligence is proved, there is no liability for damages on auditor unless the following conditions are satisfied. The first condition is the auditors owed a duty of care to the aggrieved party. Secondly, there has been a failure to conform with the standards of reasonable care and skill as expected from the auditor while he is conducting the audit of the company accounts. And lastly, the aggrieved party has suffered an actual loss due to such negligence by auditor. So, when these conditions are satisfied, then the auditor can be held liable for damages. There are some legal cases in which auditors have been held to be negligent. The first case is Leeds Estate Building and Investment Company versus Shefford. In this case, the company was formed to deal in mortgage loans, and the Articles of Association required the dividends to be paid out of profits and the remuneration to the directors to be prorated to dividends. Here, in this case, the auditor did not examine the articles properly, and the auditors passed the accounts for a number of years, and those accounts were always manipulated. So, all this resulted in payment of remuneration and dividends out of capital, which would have been paid out of profits. So, the court held that it was the duty of the auditor not to just confine himself merely to check the arithmetical accuracy of the balance sheet, but to also see that it was a true and accurate representation of the company's affairs. So, it was held that auditor has a duty that the financial statements of the company, the P&L account, the balance sheet, they should represent a true and fair view of the company's affairs. And if he doesn't see to this, then he is held liable. Next such case is London Oil Storage Company Limited versus C.R. Haslick and Company. In this case, the auditor failed to verify the amount of petty cash in hand that was declared to be £796 in the accounts, but in reality, the petty cash existed to be only £30. In this case, the auditors were found guilty of negligence, and it was held that verification of assets that are stated in the balance sheet, it is an important duty of the auditor to verify the assets. So the auditor should be held liable because of his negligence in the fact that he did not verify the assets properly, which are mentioned in the balance sheet. Next topic is liability for negligence towards third parties. There are various interested parties such as creditors, bankers, potential investors, etc., who place reliance on auditor's report to take important decisions. So, it is the auditor's liability in cases of fraudulent misrepresentations resulting in any kind of physical injury or any financial damage to the third parties. Now, in this case, the liabilities of negligence towards third parties, the court's view can be divided in 4 phases. The first phase is acceptance of doctrine of privity by courts. According to it, an auditor owed a duty of care only to his client, with whom he has a contractual relationship. Therefore, no such third party, including creditors or bankers or potential investors, no third party could hold the auditor responsible in case of any negligent behavior. Second phase is erosion of doctrine of privity. This erosion of doctrine of privity, it began with the decision in Headley case. The case involved a credit report by a bank. On that report, a third party relied and the third party lost its investment. So the court held an auditor's negligent behavior and the court extended auditor's duty of reasonable care towards a restricted class of third parties, such as a bank that has loans outstanding to the client. So this phase extended the auditor's duty to not all the third parties, but a restricted class of third parties, such as a bank that has loans outstanding to the client. Next phase is extension of proximity. In this phase, the scope of auditor's duty towards the third parties was again widened. So an auditor can be held liable for a loss which is caused by his careless auditing of the company's accounts to a third party, even in that case in which he did not even know the existence of the third party at the time of auditing the books of accounts. The last phase, the fourth phase, is proximity and reasonableness. It was held that no single general principle can be applied to determine the duty of care of the auditor towards the third parties. So it all depends on the damage that is suffered. Like is it the kind of the damage which the auditor was under a duty to prevent, or if the auditors knew that the financial statements were being shown to the plaintiff for a specific reason, like if the auditors knew that the financial statements were being shown to the plaintiff or the financial statements were being submitted to the plaintiff for inducing him to invest money in the company. So in that cases, the auditors can be held liable, and this decision has been followed in various courts' judgments. However, the law relating to liability of an auditor towards the third parties, the law is still evolving and the courts can take a different view depending upon the circumstances. Next topic is liability under Companies Act 2013. Under the Companies Act, we have civil liabilities and criminal liabilities. First, we will discuss about civil liability. Under civil liability, we have liability for misstatements in prospectus. Section 35 lays down the provisions regarding civil liability of promoters, of directors, and other persons who are authorized to issue the prospectus. And this also include auditors. So, auditors shall be held liable for any misstatements in the prospectus. The auditor shall be held liable to indemnify the aggrieved party against all the damages or costs or expenses which are incurred by the third party because of reliance upon such misstatements or such untrue statements. However, if the auditor withdrew his consent before the issue of the prospectus, or if the prospectus was issued without his knowledge or without his consent, then the auditor can escape his liability in these cases. Second is liability for misfeasance. Now, misfeasance is a breach of duty or a breach of trust. The auditor would be guilty of misfeasance if he has been found guilty of breach of trust or negligence in performance of his duties, which has resulted in loss of the damage to the company or the company's property. And here we have a few cases. The first such case is the London and General Bank Limited. In this case, the bank had advanced loans against insufficient securities, and no such provision for bad debts was created against these loans. The auditors also, in this case, did not mention anything explicitly about this, about the loans, about the insufficient security, about the bad debts in the report that the auditor gives to the shareholders. So the directors also paid the dividends to the shareholders out of capital and not out of profits. So the auditors were held liable for making good the company's loss. The next such case is Westminster Road Construction and Engineering Company Limited. In this case, work in progress disclosed in the balance sheet was overvalued and liabilities were understated. The auditors also relied upon the certificate of the management as to the valuation of work in progress, and therefore the dividends were paid out of capital and not out of profits. And the court held auditor liable as he failed to make specific inquiries regarding the existence of liabilities. So the court held that the auditor should make inquiries regarding the liabilities, regarding the work in progress over here, the assets, which the auditor did not do so in this case, and he just relied upon the certificate of management regarding the valuation of work in progress. Next is criminal liability under the Companies Act 2013. The first liability to be covered over here is misstatements in prospectus. According to Section 34 of the Companies Act 2013, if a prospectus includes any untrue statement or any misstatement, then the auditor who authorized the issue of the prospectus can be sentenced to an imprisonment for a term which may extend to 10 years or a fine which will not be less than the amount that is involved in the fraud, and that fine may also extend to 3 times the amount that is involved in the fraud. However, the auditor can escape his liability in this case if he proves that that statement was immaterial or that he had reasonable grounds to believe that the statement was true. Second liability is penalty for non-compliance by auditor. According to Section 147, subsection 2 of the Companies Act 2013, if an auditor of a company contravenes any of the provisions relating to appointment of auditor or contents of audit report or compliance with auditing standards or signing of audit report or prohibiting services, then the auditor shall be liable with a fine which will not be less than Rs 25,000 and which may extend to Rs 5 lakhs. Next liability is production of documents and evidence. If the auditor fails to give assistance to an inspector appointed by the central government to investigate the affairs of the company, then in that case the auditor shall be punishable with an imprisonment and fine too. Next is power to summon persons suspected of having property of a company. Now, during the course of binding up of a company, the National Company Law Tribunal may summon before it the auditor if the auditor is suspected to have possession of any property, any books or papers or any document of the company, or if the auditor is capable of giving any kind of material information regarding the company to the tribunal. Now, in this case, if the auditor fails to appear before the tribunal, then he can be arrested. And last is penalty for false statements. If any person deliberately makes a statement in any report, any certificate or financial statements or any other company documents, or he deliberately omits any material fact, then he shall be punishable under the provisions of the Companies Act 2013. with this, we have come to an end on the liabilities of auditor. Thank you.